Please give us a brief introduction.
Good evening, sir. My name is Smita Mohapatra. I have completed my LLB from Madhusudan Law College, Cuttack in 2023, and now I am pursuing LLM in ICC's Law College, Bhadrak. And together with I am preparing for judiciary, and this is my first attempt. And my hobbies are painting, portraits, and sketching, etc.
Okay.
Okay. Smita, can you define what is justice as per your opinion?
Ma'am, Megan.
What is justice? What do you mean by justice according to you?
Uh, yes, ma'am. Justice means uh, what is the judgment which is given in a fair way and which is uh, not biased and it is not uh, in an impartial way it is given and accepted by the public. It is justice.
Now, can you tell me that suppose there are certain cases in which the evidence which are presented in the court are tampered or they are changed, okay, and you know that corruptions also has been done there, and you know that the person who is done guilty will be given as per law, but if the evidence would have been truthful in nature, then the judgment would have been something different. So, if such a case comes to your court where you know that the evidence are tampered, then there are a lot of pressures on you. How you are going to handle such cases?
Yes, ma'am. Ma'am, if I know that the evidences are tampered, then first of all, um, I would tell the means the advocate and the witnesses about the consequences of tampering the evidences, that it is punishable under the law under section 293 of IPC. There are punishment for it, and if after that. I will also check it properly. I will review the all the evidences properly, so that I could give justice in a fair way, and I would also refer to make means by the technology I would record the data so that tampering should not be done by the persons.
Okay. Now, there's you know that a lot of children nowadays they are we are generally seeing in the society like special education needs. Okay, they are autistic, they are in the autism spectrum, or they are in ADHD, or dyslexia, or cerebral paralysis. This such type of things we are encountering in scenario right now. And if a person comes, if a victim or a victim comes having such one of these conditions, then how you will give judgment in that case?
Ma'am, actually,
So they are not able to express
the
themselves.
fast line is not audible.
Uh, okay, now am I audible?
Yes, ma'am.
Nowadays in society we see some children who
Yes, ma'am.
are we cannot say they're mentally challenged, they are special children, they have such special needs, they have cognitive disabilities, they are in the autism spectrum, or they are hyperactive, or dyslexia, they are suffering from dyslexia, or they are cerebral paralysis, and a lot of things are happening
Yes.
nowadays. So these children are not able to express themselves. Okay, they need some certain special teachers or educators are there appointed for them. Now, if such a child gets victim to one of the cruelties of society and goes to your court and seek justice, then for such children, how will you give your judgment on which basis, and what are the steps will you follow so that a proper justice will be given to such children?
Yes, ma'am. Um, yes, ma'am. If they are such type of children, then first of all, um, I would order for the rehabilitation and for their um, medical treatment if any injury happened to them. Then after that, I would ask them like there is a void test, but that is for the um, means the offender. But here in the victim case, also I would ask them that what happened to them. In a friendly manner, I would ask them, and then after that, I would and even in the rural areas, I would make some awareness program so that the people should be educated relating to these things, that they should not behave to them in a such harsh way. And also these are my points.
So, okay. So we'll start with procedural law, CPC. So, can you tell me what is the difference between rejection of plaint and return of plaint?
So rejection and return.
Yes, rejection of plaint and return of plaint.
Yes, sir. Sir, rejection of plant is defined under Order 7, Rule 11 of CPC 1908, and return of plant is given under Order 7, Rule 10 of CPC. And rejection, there are following grounds where rejection is granted: that if there is no cause of action there, and if the suit is not properly valued, and the court has asked for the value but the plaintiff failed to do this, if the suit uh, is not properly um, properly um, and if, sir, it is not it is barred by any law, and if according to Order 5, Rule 9, it is not the summon is not provided to all person, if it is not uh, paged, duly paged, and these are the things where it is rejected. And if there is any jurisdiction problem, like it is not filed under the right jurisdiction, then it is returned under Order 7, Rule 10.
Okay. So, can a order which has been passed by a foreign court be implemented or executed in India? If yes, what are the conditions for that? And if no, then in what conditions it cannot be implemented in India?
Sir, according to section 13 of CPC 1908, a foreign judgment is conclusive and it can be executed in India. But there are some exceptions where it is not conclusive, it cannot be executed in India. And those cases are if the foreign judgment is not given on merit of the case, and if it is not given by a court of proper jurisdiction, and if the foreign judgment is barred by any law or barred by any Indian law, or if it is against the international law, or if it is against the natural justice, and if it is obtained by any fraud.
What do you mean by an interpleader suit, and what are the exceptions to it? Means when can interpleader suit not be filed?
Sir, Section 88 of CPC talks about interpleader suit, and also the procedure of interpleader suit is given under Order 35 of CPC. And according to this, interpleader suit is a suit which is filed between two defendants. Um, two defendants, and when the property is with in the presence of a in near the plaintiff, and he is ready to give it to the rightful owner, and only ask the court for a charge and um, cost. And the exception are where the interpreter suit cannot file is if there is any collusion between plaintiff and defendant, if the defendants are decisive. In these cases, interpreter suit cannot be filed. And if also the plaintiff has any personal interest upon that property.
Okay. So now let us come to your Evidence Act. So can you tell me, can only dying declaration be the sole basis of conviction?
Yes, sir. Dying declaration, if it is true, and if it is given on under the fit state of condition, fit state of mental state, then it can be a sole basis of conviction.
Can you tell me what are the guidelines given by Supreme Court in this matter? That is conviction solely based on dying declaration.
Uh, yes, sir. There is a relevant case. Um, but sir, I am unable to recall it now.
Okay, fine. So you know what is res gesta?
Yes, sir.
And
Sex.
if you know, if you can compare in with Indian Evidence Act and Bharatiya Sakshya Adhiniyam, which sections it is there in Indian Evidence Act and Bharatiya Sakshya Adhiniyam.
Yes, sir. So, res gesta in Indian Evidence Act, it is given under Section 6. Section 6 of the Indian Evidence Act 1872, that when any fact which is by itself or in connection with another fact which is in same transaction is relevant, then it is called res gesta. And in Indian in Bharatiya Sakshya Adhiniyam, it is given under Section 4, I think. I'm not sure.
So can you give comparison between Indian Evidence Act and Bharatiya Sakshya Adhiniyam, especially with relation to electronic evidence?
Sir, no,
Okay,
sorry.
fine. It is fine. Okay. So now let us go to Constitution. You know about Article 14?
Yes, sir.
So what is the title of Article 14? What does Article 14 say?
Sir, Article 14 says equality before law and equal protection of.
Okay, now tell me these two different concepts. What do you mean by equality before law? From which country you have borrowed it? And what is equal protection of law? From which country you have borrowed it?
Sir, equality before law means all are equal before law, and equal protection of law means sir, I'm not sure about it from which country it has been borrowed.
Okay. Equal protection of law means similarly situated people or similarly placed people will be treated similarly. Okay. That means equals and unequals will be treated differently. So two member of parliaments will be treated in the same manner. Okay, but the member of parliament and a common citizen, there will be difference in their treatment because they are not similarly situated, right? So that is an American concept. Okay, that is equal protection of law. Equality before law is basically a English concept from English law. Okay, which was propounded by your jurist A.V. Dicey. Okay, in his concept of rule of law. So under rule of law, he had given certain propositions. From there, you can say it is a corollary, but it has been derived from there. Okay, right. You know about Article 32 of the Constitution?
Yes, sir.
So tell me what is the difference between certiorari and prohibition?
Yes, sir. Sir, prohibition means to prohibit, means the when any lower court means the yes, sir. Any lower court gives any judgment or order which is wrong, means irrespective of jurisdiction, then the higher court prohibits it. But certiorari means the higher court means sir. Certiorari means after judgment, and prohibition means before judgment. The higher court prohibits the lower court.
Prohibition is before the judgment, or the court which does not have the jurisdiction, okay, is
Yes,
taking
sir.
up the case, okay, before it gives the judgment. Certiorari on the other hand can be, so that means your
After.
prohibition is preventive in nature. It prevents a incompetent court without jurisdiction, okay, in adjudicating matters which are outside its jurisdiction. So it is preventive in nature. Certiorari on the other hand is both preventive as well as curative. So ସେଇଟା ଦି ଆଡୁ କାମ କରିବ. Okay, before also it can be done, and after also it can be done. Okay. Good. So that is just remember these two words. Okay, that is your prohibition is preventive in nature. Certiorari is both preventive and curative in nature. Okay, fine.
Yes.
So out of these writs, okay, which writ is can be applied or can be enforced on private individuals also, not only government authorities or judicial authorities or quasi-judicial authorities, but also on private individuals.
Sir, quo warranto.
No, quo warranto is for
Sir,
public office.
habeas corpus. Habeas corpus.
Yes, habeas corpus.
Habeas corpus.
Okay, that can also be given to.
So illegal detention it is used.
Yes, for the common people, okay, private citizens.
Yes,
it can be. Have you heard about 35A of the Constitution? It was in news during this 370 when Article 370 was diluted. So, what is this Article 35A?
No, sir.
Okay.
Read this.
Okay, do you know who is the Chief Election Commission newly appointed by India?
Yes, ma'am.
Okay, you find it out. Okay. Now,
I
why
read
I
this
ask? Okay, why I ask this question is that suppose you are going to give a judgment, and a case comes to just 10 days is there for the election to take place, and you know the scenario, it's a high stress scenario, and 10 days are there for the election to take place, and some political parties have done certain disruptions, and they are dragged into the court where you are one of the judge, you are the judge, okay, and you know that there are a lot of pressures from the media as well as the political higher handedness is there. So in that case, when elections is just approaching, how will you give your judgment?
Okay, ma'am. I will ensure that means judiciary is one of the separate part from the executive and legislative, and I would ensure that any external pressure should not be applied on the judiciary, and also I would adhere to the judicial act, and I would maintain my confidentiality and transparency and integrity in the judiciary, so that no external pressure can influence me, and also if there is any external pressure instead of this, then I would ask suggestion from my um, superior authorities, and also ask help from the police also, and uh, in giving judgment there should not be any impartiality. I would ensure that, and follow the rules of law only. According to the evidence, I will give judgment.
Now, suppose again, this is a situational question. Like, suppose in your court, there is a case comes where the evidence, the person who is to be given act as evidence, is not there to testify. He denied that he will not testify. Then there will be a problem. So, when the lawyer will be giving the arguments. So, in such cases, how will you deal with that?
Yes, ma'am. If the person who is the witness and he is denying to giving his testimony, then uh, I would also say him that what is the consequence of it, that, and I will also ask that if there is any inducement or any type of forces, means any type of threaten it's on him, that why he is denying to um, give evidence or give testimony in the court, and if there is anything that, then he has not to worry, he can give testimony, and uh, if he still not uh, means desire to give, then I will ask the police to investigate the matter, that what has happened.
Okay. One last question from my side is that nowadays we are seeing lot of cases in and around a woman happening in the society. Whether it's a molestations, rape, divorces are increasing, abuses are increasing. So, as a judge, what is your opinion that should be taken within the legal boundary so that to some extent this can be decreased?
Uh, yes, ma'am. Uh, uh, yes, ma'am. The means the provisions where the penalties and the punishment should be uh, means strictly followed, and um, the and means the women should awareness program should be made in mainly the rural area and the tribal areas, so that the women should file complaint against it. The females are mainly due to the societal pressure and thinking that it will harm their family's reputation, they are not complaining against the domestic violence and the molestation what is happening with them. So I will make awareness program that if anything is any type of these things are happening with them, they should make a complaint in the court or in the police station, so that rehabilitation of them will we will do the rehabilitation of them, and also will means conciliate with their family and with their husband or whoever with them, or any conflict happens, and also uh, give punishment to the person if he has done anything wrong.
Okay. In CRPC, is there any provision that even if the accused is acquitted, still the court can award compensation to the victim?
Yes, sir. Under 357A victim compensation scheme, uh, if the accused is acquitted, then also the uh, victim can ask the court to compensate him, the state legal service authority and state legal service authority to compensate him.
Right. So, what were the optionals that you have taken for this exam?
So my optionals are personal law and contract law and crime law, crimes and all.
So my last question to you would be related to contract law. So we know the concept of quasi-contract, right? Now, but in the statute in Indian Contract Act, the term quasi-contract is not used. So tell me something about it. What is the term that has been used in the Indian Contract Act for quasi-contract?
Sir, unjust enrichment.
Just go through it. Okay, what do you mean by quasi-contract? What is the meaning of the word quasi?
Sir, quasi means it's an obligation upon a person if he has get benefited by, has used the benefit of someone's, then he has he can get reimbursed by that person. He can take reimbursement from that person.
Quasi generally means similar. Okay, similar. Okay,
Yes, sir.
fine. So that will be the end of the interview. Now my feedback. तो आपण कंटेंट जहाँ आंसर करछथि आपण टी सीरियस हे होछथि कि स्माइल टा मेंटेन करंतो आउ टिके बॉडी मूवमेंट होछि राइट आगु को पछुबडे सेटा टिके देखिबे सेटा ताकू टिके ऑड लागिवो राइट तो सेटा देखंतु आउ किछि व्यस्त होबार नै 10टा क्वेश्चन भितरु जनरल इंटरव्यू रे 3टा आंसर न दबा इज वेरी वेरी कॉमन आपण केबे भी 10टा प्राय जो बहुत भलो मार्क्स रखते भी सेमति भी होएनी राइट कि आपण सब क्वेश्चन आंसर दे सो ठीक है जोटा आसु भलो देबे जोटा आसुनी बट कॉन्फिडेंस रे आंसर ओके सो आई विल गिव यू अराउंड 68 आउट ऑफ 100 आपण चेष्टा करू तो 80 आडू ताको नबा पे ओके बेस्ट विशेस फ्रॉम माय साइड
Smita, are you nervous today? Bit nervous? सेटा हुए ओके द नर्वस है जे ना हमको लागे जे हम ठीक रे क्वेश्चन टा सुन लेनी की ठीक रे आंसर टा देई परलेनी आई टोल्ड यू नो इफ यू हैव आई मींस ऑल द इंटरव्यू स्टूडेंट्स आर गिविंग इंटरव्यू थिंक व्हाइल एंटरिंग द रूम that I am one of the luckiest who had cleared mains. So that confidence should be there that I can, if I've cleared mains, then I can be one of the candidates who will be chosen after the interview, and I will be a judge. It's just one threshold. Okay, gote unity deiba baki achi hela. So eti au nervousness hebeni, confidence jemti ebe hosuchunti hasibe because you are capable. It is not a thing. ଦୁଇଟା ଜିନିଷ କହିବି ଆଜି କ୍ୱେଶ୍ଚିନ୍ର ଫର୍ଷ୍ଟ ହେଲା ଆମେ ଯେତେବେଳେ ଆପଣଙ୍କୁ କହିଲି ସ୍ପେଶାଲ ଏଜୁକେସନ ନିଡ୍ସ ଉପରେ ସେତେବେଳେ ମୁଁ ଭାବୁଛି ଆଜ୍ ଅ ଜଜ୍ ୟୁ କ୍ୟାନ୍ ଆଡ୍ ଦିସ୍ that lot of government organizations are working on these children. So a judge will sit down with that government organization, make the victim being analyzed by that organization, by the psychologist, by the cognitive therapist. Okay, and they are better able to explain the condition which that victim has gone through. Okay, in presence of that we can give the judgment. That is one thing. The last thing that I ask you is about the awareness that you told. No, you should make people aware. So one thing which I feel means should be there that we should add certain basic laws and the punishments being associated with that. Like I told you about divorce cases and child abuse and molestations and rape cases. So in the school curriculum, okay, there are two benefits. Like first is that all the students as well as the teacher who is teaching them will be aware of that. Okay, and secondly is that students will try to adapt law as their career also. So it won't be, if we in a very basic way, in a very simple way, we make them aware that this is good, this is bad, and this should not, if you do this, then this is the punishment. So in the very child, when a child in the very basic stage is like a, you can say it's like a clay, in which way we can mold it, it will be getting molded. ओके तो छुआटाକୁ ଯେମିତି ଆମେ ପଢେଇବା ସେ ସେମିତି ପାଠଟା ପଢିବ ତ ସେଇ ସମୟରେ ଯଦି ଆମେ ତାଙ୍କୁ respecting women, giving them respect and treating them that way, and if we don't do that, this is the police will put you behind bars and all those things will be there. It won't threaten them, but it will make them realize that laws are so strict in their countries that this should not be taken. And girls also knows their rules, and they will be aware of this, and the teachers and the higher those who are teaching also aware of this. Okay, so this is the thing that I feel myself, and you can use it in your answers. Okay, out of 100, if you say me, I will be giving you 70, expecting that next interview you are going to have more than that. Okay, nervous heavily. Okay, thank you, all the best.
Thank you.